rise.
Thank you. Please be seated. This is a time set for oral argument in our case number CACV 19-0061, Greenberg versus McGowan et al. Each side is allocated 20 minutes for oral argument. Appellant may reserve a portion of that time if you wish to do so. If you wish to do so for rebuttal, you'll need to keep track of your own time at the podium clock. Out of respect for counsel, I would ask all those in attendance to make sure your cell phones are off. That also will avoid any embarrassment if your phone goes off during the oral argument. We've read the briefs. We've conferenced the case. We're familiar with the record. We'd encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded, and they will ultimately be posted to YouTube. So please, as you begin your argument, please tell us your name and the party that you represent. With that, Mr. O'Leary, you may proceed.
May it please the court, my name is William O'Leary. I represent Linda Greenberg, in her appeal. It has 4 issues that we seek to address. First, the erroneous granting by the trial court of summary judgment against her. Second, the wrongful denial of her motion for reconsideration. Third, the wrongful denial of her motion to amend her complaint. And fourth, the wrongful award of attorney's fees to the McGowan and Inscription Canyon Ranch parties. Starting with the granting of summary judgment, that has 3 issues that I'd like to address on the appeal. The issues are: 1, whether the CC&Rs allow the McGowans to keep donkeys on their property; 2, whether the structure on the McGowan property is an RV garage or a barn; and 3, whether the trial court committed error by dismissing Ms. Greenberg's breach of her contract damage claims due to a minor and curable discovery violation. So, starting with the interpretation of the CC&Rs as to whether or not donkeys are allowed to be kept on properties in the association. Generally, the court, trial court's instructed, and in this court's review, to give plain meaning to the terms of the contract, the CC&Rs, that issue here, and to look to the specific terms over the general terms in interpreting the CC&Rs. And as a POW court that we've cited, the trial court cited, both parties have cited, that give us the instructions as to how to interpret CC&Rs. The POW court has instructed that we look to the intent of the parties, the drafters of the CC&Rs. And trying to determine what their intent is, the court in POW gave us 3 factors. 1, the language of the CC&Rs themselves. 2, the circumstances regarding the creation of the CC&Rs. And 3, the purpose of the CC&Rs. And as in the POW case, I think in this case as well, what we need to look at in interpreting them are the language and the purpose of the CC&Rs. And the CC&R paragraph at issue is 10 in regards to the animals, and whether or not the reading of that should be a list of permissible animals, or is it a list of what is excluded or not permitted animals. And in our position that the trial court, when it was looking at this paragraph, misread and misinterpreted this list to have been a list that defines what animals are excluded.
Counsel, is your reading of paragraph 10, does that turn on whether paragraph 10 is comprehensive? In other words, does it list all possible uses and all prohibited uses? Or if there are other portions of the CC&R that need to do the work, would that have effect on you?
It lists all allowable, permissible animals.
And help me on the specific language, help me get up to speed with your argument. Because I struggle with 10. It seems to me it lists some permissive uses, it lists some prohibited uses, but the thought that it covers the waterfront, I struggle with.
Yes, Your Honor, and understandable. And I think we agree there's, as I think in the McGowan brief, a lack of clarity is certain there. But when you read it, the exceptions in that paragraph, what is excluded, are modifying terms of the permitted animal. And they're written in sentences with So, for example, the first sentence, and that's brought up by McGowan in their brief, they claim the way the first sentence is written means that this paragraph should be written as an exclusionary paragraph. Because
Well,
it's
the first sentence clearly does exclude certain types of animals.
correct, and it's just the way that the English is written in that sentence. So the beginning sentence, the first half of it before the pause, the comma, is to exclude poultry and fowl, but we allow birds, and then we further modify birds to be inside birds not more than 3. So the sentence is birds are allowed, but what kinds aren't allowed? And so we then bring it back to the more restrictive. Birds are allowed in numbers less than 3, no poultry, no fowl. And when we're reading it that way, when we read this whole paragraph that way, we're not to lose sight of what's the purpose of the CC&Rs. In the CC&R state, the purpose is to maintain a first-class, single-family residential community, not a farming community. And so to exclude noisy birds, smelly birds, to just have birds inside, then that furthers the purpose of it. The next sentence that we look at, dogs and cats are allowed. Well, that sentence goes on further, except for commercial use of these dogs and cats. We read further down, well, 4-H animals are allowed, except
It says
for
horses.
horses
It's
too.
not just 4-H animals. That's horses or 4-H animals.
Right, and I'll get to horses because that's the crux of the paragraph. But in reading it, what we're looking at is 4-H, except for swine, because typically a swine could be a 4-H project, but we don't want swine allowed, or the poultry and fowl again. Again, a modifier of 4-H, and horses.
Let me ask you about the 4-H, and I understand that the parties have stipulated that these donkeys are not 4-H animal projects. But what's your reading of the CC&Rs if someone had a donkey that was a 4-H animal project? Would that be prohibited by the CC&Rs or allowed by the CC&Rs?
Allowed.
Okay.
And the reason is because 4-H is unique. They're not there permanently. It's temporary.
10 years, maybe?
No, 10 months.
Well, I think you can be a 4-H'er from when you're 8 until you're 18, maybe
Right,
longer.
right, but the projects last. They just rotate. The project isn't a 4 or 10-year project for the kids. They take them to market or auction, if you will, at the end of the project.
Well, they don't.
Take donkeys to market.
I don't think there's a market for it. That's why there's no donkeys in the 4-H.
We don't know this, right? And I was in 4-H a long time ago in a different part of the country, but if you had what I will call a companion animal as opposed to a market animal, those projects could last for years and years.
And that might be one that is permissible under a 4-H if there's a kid. But then again, it's got a limit. We still have the limit because of the age.
There is a limit, and I get as well, I don't want to take us too far down that path because the parties have stipulated that's not the facts that are presented here.
Right. And along those lines, when it says horses, we clearly have agreed the horse is a different animal from the donkey. And that's the important aspect
What
of
about
it.
a mule?
A mule isn't allowed either. That's different as well.
Well, it's half a horse.
Half a horse, right. But again, let's look to the purpose.
So half of it's allowed.
Half of it's allowed if you could
Which
separate
half?
it. Which half? I guess that's Solomon's question, right? That can we split it? No. And so the noisiness, the purpose of it is to maintain a first-class neighborhood, and so we need to keep going back to that.
And I'm with you there, but you've already, I think, conceded in a somewhat different world, without regard to anything other than paragraph 10, that donkeys could be allowed on the property for maybe a decade. And if you have serial 4-H'ers, maybe even longer than that. So is your point that a first-class neighborhood could never have donkeys?
It would be based on the drafting of the CC&Rs. And so I think they could if they allowed them, but in this case, they didn't. And if we look to what the trial court looked at, and part of its interpretation was this trail easement paragraph that allows riding on the trails by horses, donkeys, and mules, it defines. And the argument being, well, if you can ride it there, why can't it live there? Well, that's not necessarily so. We have lots of CC&Rs where you could take a semi-truck to move a house, but the semi-truck can't be parked there. Or you could drive an RV to load it to take on a vacation, but the RV can't park there. And so the fact that it could be ridden there doesn't, one, automatically lead to that you must be allowed to house it there, because housing is much different than taking a daily ride through the trails and then trailering it to a boarding facility.
Is there any evidence in this record that would indicate that it takes more or less to house a donkey versus a horse? Are they more noisy? Do they stink more? I mean, what is there that would necessarily mean that it's not a first-class neighborhood because you choose a donkey over?
The noise, Your Honor. And there has been concession, I believe, that these are noisy animals as compared to a horse. The brain, it's a different noise and sound that's more continuous.
Is that a finding or a stipulation somewhere in the record that we could find?
I don't know that it was a finding, but I believe it was part of the discussion that we've had at oral argument in the motions for summary judgment. It wasn't based on, expert or formal stipulation, but the general consensus is that it is a noisier animal than the horse. Thus, the furthering the purpose to exclude them to maintain a first-class neighborhood.
Except for those 4-H.
The 4-H, right, and there's the model.
Which kind of undermines that.
It undermines it a bit, but at least it gives us, again, I mean, we have potentially your serial. But in drafting that, though, the knowledge was, I mean, you can infer that the knowledge is of 4-H doesn't allow for donkeys. And so by allowing 4-H within the definition of itself.
That you keep saying that, but I don't know that. I don't know whether or not a 4-H has a project for donkeys. They very well could.
Well, that's been agreed to in the case, too. That was conceded during oral argument, that there wasn't the dispute that a 4-H project includes a donkey.
Well, not in this case.
Well, in any case. I mean, or at least, I mean, in this case, I can't say that we've stipulated to the worldwide, but it was agreed in argument that 4-H doesn't allow a donkey. And so by saying 4-H.
Let me just pin that down a little bit, because you're speaking in the passive voice and you're saying it was agreed. Did the parties stipulate, or did the opposing party concede that 4-H projects in this world do not include donkeys?
Concession,
and if so,
not formal stipulation.
Could you point me to where that is?
I can't right now point you to the specific. And I could say in oral argument during the motions for summary judgment.
Okay.
But I'll tell you, there wasn't a formal stipulation in that language or anything paper filed.
Okay.
Let me ask you, counsel, because you're right that paragraph 10 is the cornerstone here. Now, there are other aspects of the CC&Rs. You've mentioned first-class community. You've mentioned paragraph 6, I think, which is the easement, and address that. Let me ask you to address a couple other paragraphs. Paragraph 13 talks about oil and mining, and that makes really clear that there's nothing that's allowed on the property that's oil and mining. It uses the term of any kind for any purpose associated with oil or gas drilling or mining. And there's another one with respect to abandoned or inoperative vehicles that again talks about of any kind and in any manner, right? Makes it really clear that that's intended to kind of cover the waterfront for those potential uses and that those are prohibited. I don't see language like that in paragraph 10. And that's one of the things that causes me to struggle with what paragraph 10 is and does.
Right, and that exclusionary language isn't as clear in it stating that horses are allowed. I think certainly that is something that could have been a clarifying term, only horses, simple as that. But when we look at the paragraph as a whole, it's listing what's allowed and further clarifying what's excluded, because it'd be a sheer impossibility to list everything that isn't allowed.
And I understand that, but that's why, the of any kind language or in any manner language caught my attention. Do we have, and again, Powell, which was a bit of a sea change in how CC&Rs are construed, focuses a great deal about the intent, right? And you cabinet those in language, circumstances, and purpose, which I think is probably as helpful a tool set as we'll have. Is there any suggestion in this record that the parties in drafting the CC&Rs, long ago, thought, donkeys, we need to address those? Is there anything in the record suggesting that that actually happened, as opposed to us now, years later, trying to interpret, an important but sort of high-arching document to see whether they are?
No, there isn't in the record. But if we look again back to the trail easement, when the drafter specifically delineated horses, donkeys, mules, you can infer drafter's knowledge that there was a distinction between them. And so in the reverse, he could have written what's allowed, horses, donkeys, mules. The drafter did not.
Does that, and I understand that logic and that argument, does that logic still obtain if paragraph 10 is found not to be comprehensive? In other words, if paragraph 10 identifies certain prohibitions, certain express uses, but then there's some things in the middle that may be allowed.
Well, I think, again, because of the way it's written, it doesn't list anything other than a horse, meaning that's the only animal that's, in that.
It doesn't list it expressly, but if we trail on down to a few of the later sentences after the first reference to 4-H animal projects and just before the second, it talks about livestock and it talks about animals, sort of even later. More generic, perhaps broader phrases. Why would those provisions be in there if the first few sentences were designed to expressly delineate the world of what is and is not allowed?
Later on, I think what we're talking about is describing the type of fencing that is allowed in order to contain the animals that were described above in that paragraph. And so it's a fence type that they're trying to delineate and describe later on, and the use of those terms isn't to expand the allowable animal that's allowed in this community.
But let me ask you, and I'll ask you just once, because there are probably several other examples that I could ask you. Wouldn't it have been better to not use the term livestock and animals if, in fact, that was what was designed to do? And I promise I won't ask that question again, because it's always hindsight. And
Right. In hindsight, yes. I think we would have liked to have seen a better drafted paragraph.
Well, especially the last sentence of the paragraph, when it specifically says, and pets of any kind. It seems to be pretty broad, and it doesn't seem that you can have corrals or other areas fenced for purposes of maintaining animals and pets of any kind if what you're saying is, the only thing we wanted there was horses.
Well, I think that reading at that end, again, is still part of what we're containing with the fence, and to just look at that section in and of itself and not the paragraph as a whole when the paragraph is trying to delineate what's allowed, because of any kind, that could expand it to everything then. And so then there is no reason for this paragraph. Unless it's excluded, and then we have excluded these certain animals, or, they excluded them by just defining what's allowed. Because I don't think we can read this as an exclusionary paragraph, otherwise everything that's not listed then would be permitted. I mean, taking it to the extreme, donkeys, rhinos, zebras, buffalo. I mean, people have those in rural communities. And so I don't think we can look at that paragraph to say, because we have some language we could stretch, that it then opens the door to anything and everything, because, again, we can't lose sight of the purpose. And I think the purpose is to contain it and restrict it in a certain fashion. And one of the other items I'd like to at least address briefly before I reserve time for rebuttal is the barn versus the RV garage distinction. That should be an issue for the jury or trier of fact, not as a matter of law for the court. There was plenty of evidence in the record to suggest that there is a reasonable inference to be drawn that this is not, as the court deemed it, based solely on use to be a barn. There's testimony of intent from McGowan's. There's discrepancies in county permits that suggested that it was being applied for as a garage. There is, just looking at it itself, that a trier of fact could see a big metal building with roll-up doors and a concrete floor to be an RV garage and not a barn. And so that should have been an issue for the trier of fact, not for the court.
Can I ask on that point, and I understand your time, but isn't the record clear that to date it's only been used as a barn?
Correct. The use, right, but the use could change tomorrow, and then use could change every day.
Fair, but we're sort of in the business of trying to resolve disputes for things that have happened, not that could happen.
Correct. And so that's why the trier of fact should decide, what is this? Not guessing based on usage, But the trier of fact, based on what it is, the sky is blue. Well, because I say it green, is it green? No. And so it should be left, that's a question of fact, not an interpretation of the contract. This is a question for a trier of fact to decide what is this structure, a barn or a garage. And so that was error that the trial court shouldn't have done it as a matter of law. And I just have a minute left. I would reserve that for rebuttal.
Of course. Thank
Thank
you,
you.
Counsel. Now, let me look to Counsel for Appley. Who's going, are you splitting time? Who's going first?
Your Honor, we are going to split time.
Okay.
And we end up with the bulk of it, given that the issues you were interested in appear to be my issues.
Very well. Mr. Beck, you may proceed.
May it please the court. My name is Andrew Beck, and I represent Jack and Eileen McGowan, who are here with in the courtroom with me today, along with some of their friends and neighbors. I'd like to start by addressing some of the factual issues that opposing counsel just brought before the court, because I think there are some of the things he said are not supported by the record. For starters, there was a stipulation that these particular donkeys were not 4-H animals, but that was as far as the stipulation went. There was no stipulation that 4-H does not permit donkeys or anything like that. We simply took the 4-H animal issues off the table because we acknowledge these are not 4-H animals, and there was nothing further on that. The other issue that I believe what my colleague has stated is not supported by the record is this question of whether the donkeys are noisy or whether there was any evidence that the donkeys were noisy or a nuisance. And it is, I'm afraid to say, quite the opposite of what Mr. O'Leary has told you. If you look at IR 125 and IR 92, which are our motions for summary judgment and our reply thereto, we attached to that a request for admission that we sent to Mr. O'Leary's predecessor counsel, saying essentially, admit that you are not making a claim for nuisance. And their response to that was, we admit that, but it doesn't matter because if it violates the CCNRs, they have to go anyway. So it was very clear, both in the briefing and in the oral argument, that there was no evidence that these donkeys were noisy, troublesome, a nuisance, or anything like that. And you can also look to the May 23rd, 2018 oral argument transcript before Judge Mackey at lines, or at page 51, line 19, where I addressed that issue. Let's talk about paragraph 10 for a moment. You asked whether it is an inclusionary paragraph or an exclusionary paragraph.
Well, it was a little more nuanced than that, whether it was intended to be comprehensive or not.
And I think it is not comprehensive, and I think I can say without fear of contradiction that this was not a well-drafted set of CCNRs.
And I'm casting no stones, because people who drafted these long ago did the hard work, to try to anticipate what would happen.
I think it's both. It includes animals that are clearly permitted, it includes animals that are clearly prohibited, and in between is this gulf of the animal kingdom that is not addressed. Because of that, I think you have to treat paragraph 10 as ambiguous. You can't treat it as merely a list of animals that are permitted, because the very first word is no. The very first clause is no poultry or fowl. So it starts with an exclusionary clause. It does have permissive clauses as well, but it does not address the animal that we're here to talk about today, and that's the donkey. So under Powell v. Washburn and applying the restatement third of property servitude section 4.1, which is what Powell instructs us to do, we need to look at the intention of the parties as divined from the four corners of the document, and also for look at the purpose for which those covenants were created. And this document does contain some hints, some evidence from which you can divine the intent. Paragraph 10 itself contains some hints. It talks about fences and corrals for, quote, livestock and 4-H animal projects, meaning livestock must be something other than a 4-H animal project, but it doesn't define the term livestock. But if you need fences and corrals, we're obviously talking about larger animals. We also talked about what paragraph 6 has to say, the bridle path easement, which, if you look at the plat, which we've attached, and that's included in the record as well, it is the 180 owners of the lots in Inscription Canyon Ranch are permitted to use that easement. And it says you can ride donkeys, mules, horses, or other animals that can be ridden.
Paragraph 6, though, kind of cuts both ways. There's something in 6 that both sides can like, and something
I
that
agree.
both sides don't.
It is not crystal clear, but I think what it does is it contemplates the presence of donkeys and mules on Inscription Canyon Ranch property, and more specifically, it contemplates, because Inscription Canyon Ranch owners are the only people that can use that easement, that owners of Inscription Canyon Ranch properties will have these large animals on Inscription Canyon Ranch property. And I certainly understand it would have been better if mules and donkeys were also in paragraph 10 and we wouldn't be here today. But it does, I think, evince a certain understanding that owners in Inscription Canyon Ranch are permitted to have large animals, whether you want to call it livestock or whatever you want to call it. This community is a community in which people have lots of large animals. If you look at the CC&Rs as a whole, taking a step back from paragraph 6 and paragraph 10, you will see repeated references to livestock, corrals, barns, stables, indicating that the keeping of large animals on these properties is contemplated. If you look at the character of the community as a whole, and we presented evidence to Judge Mackey that was uncontroverted, this community is not urban. It is not suburban. It is 15 miles outside of Prescott. Out Williamson Valley has large lot sizes, multi-acre lots, and lots of people have large animals on them. There are 17 barns in this 180 lots. There is at least one other donkey and mule, and I understand that there's a non-waiver provision in the CC&R, so that is not dispositive. But this is a rural community where people have large lots and they keep large animals. And I think if you look at all of those factors taken together, along with the hints that we can divine from paragraph 10 and paragraph 6, it leads clearly to the conclusion that donkeys are a permissible animal to be kept in Inscription Canyon Ranch, and Judge Mackey was correct in so concluding. The barn. The parties litigated this entire case with the understanding that if this building is a barn, it is permissible under the CC&Rs. If it is a garage, it is not permissible. So we spent nearly 2 years litigating these issues.
If it looks like a garage and it functions as a garage, why isn't it a garage?
It doesn't function as a garage.
It sure looks like a garage to me.
No vehicle has ever been pulled into, no RV or other vehicle has ever been pulled into this building.
But it's got a nice big RV.
It has a nice big door, but so do all barns.
What do we call those doors? I forgot.
A roll-up door.
How about a garage door?
How about a barn door?
Have you? Boy, I've never seen a barn door like that.
Interesting you should mention that, because that is in the record as well. How did my clients select this barn? They went to one of their neighbor's house, a neighbor named Ken Rosemeyer, who has a very similar building that he uses as a barn. It has the same kind of large roll-up door, and there's been no argument that that building is anything other than a barn. My clients went to the website, barns.com, and bought the materials to build this building. It is a barn. It has been used as a barn since it was built. But more importantly, plaintiff bears the burden of proof of showing that this is not a barn, because she is the one seeking injunctive relief. And in order to do that, she really needs to show two things. One, what is a barn? Because it's not defined anywhere in the CC&Rs themselves. And two, how does this building not comply with that definition? Because it's not defined anywhere, under the Watts v. Medicis Pharmaceuticals case, the Supreme Court has instructed us to use common meanings of the words, and if necessary, pick up a dictionary. And in fact, the Arizona Supreme Court has done that to define the word barn previously in 1935 in the Washington v. State case. The Supreme Court picked up the dictionary and said that a barn is defined as a covered building used chiefly for storing grain, hay, and other farm produce. It found that the evidence in that case supported that the building was a barn. We offered to Judge Mackey a more modern dictionary definition from Webster's dictionary, but it's largely similar. A usually large building for the storage of farm products for feed, and usually for the housing of farm animals and farm equipment.
Counsel, let me ask you, this is something, believe it or not, I've looked at in fair detail, the use of the dictionary. And dictionaries in that respect really best to show what a word could mean as opposed to what a word in context does mean?
And Your Honor, I think that is a valid way to look at it, but the point is that plaintiff has not offered a single other definition of barn that they think is applicable. They have not propounded what they think a barn is and why this building does not meet it. They have not offered any evidence whatsoever that this building does not meet any given definition of a barn. And under Orem School v. Reeves, the non-moving party must come forward with some sort of disputed issue of material fact in order to justify this going to a jury, and they did not do so despite being given the opportunity to.
What would intent instruct that inquiry?
We argued at the trial court that it's irrelevant because, I may intend a shack to be a mansion, but that doesn't make it so. It is, what is the building used for, I think, is the most logical way to look at what a building is. This building, again, meets every definition of barn that was before the trial court. It has been used for the housing of the donkeys that we've been talking about. They store their hay there. They have a scissor lift there that they use to bring in large bales of hay for the animals. It has corrals inside. It is, and has been since it was constructed, used exclusively as a barn, and plaintiff has offered no evidence whatsoever to the contrary.
If they also may occasionally park a vehicle, does that change things?
And Judge Mackey brought that up at oral argument, that as soon as you pull an RV into this building, then we're going to be here again. And I think he's right about that. That if we change the character of the building by changing the use of that building, then plaintiff does have a viable reason to come back before the court and say, okay, now they're in violation of the CC&Rs. But the point being that since this building has been constructed, it has been exclusively used for a permissible use, and unless and until that changes, there is no basis for injunctive relief by the trial court or a finding that there's a violation of the CC&Rs when they have no evidence to suggest that. And given that my time is running down a bit, unless you have other questions for me on barns and donkeys, I will turn it over to my co-counsel.
Thank you, Mr. Beck.
Thank you, Your Honor.
Mr. Suits.
Thank you, Your Honor. Your Honor, I'm going to work a little backwards given the time I have and discuss the allegation that the court's denial of leave to amend was inappropriate. Plaintiffs argue that because the ARC, who is my client, I represent the Architectural Review Committee and separately the Inscription Canyon Ranch Water Users Association, which for purposes of today we'll call the Water Board. The assertion is that because the ARC argued in its summary judgment motion that it lacked legal existence, that plaintiff hadn't been put on sufficient notice in order to act. The record indicates clearly this is not the case. In January of 2017, in response to the complaint, the first thing we did was file a motion to dismiss. That motion to dismiss argued that the complaint was bereft of allegation that the ARC is a legal entity. It argued the ARC is not a corporate entity, nor any legal entity, cannot appear before the court, that if it was an unincorporated association pursuant to ARCP 23.2, they were required to name certain members. They did not do so. I will direct you to item 31, index number 31. This is their opposition brief where they say at page 9, lines 1 through 10, line 11, since the ARC is not explicitly accepting, since the Water Board was not explicitly accepting liability for the conduct of the ARC, plaintiffs argued, quote, it is evident that the ARC and its members are liable for their own errors and omissions. If the ICR, that's the Water Board, has no liability for the ARC's actions, then it cannot be that the ARC is an entity that is not subject to suit. To find otherwise would insulate the ARC from any possible liability, which cannot be correct. Now, we'll argue that point, whether that's correct, given the way these entities were formed, but the important part here is that as of February 8th, 2017, they were clearly on notice that we were arguing that the ARC was not a legal entity. And so the assertion that it is my fault because I didn't also establish an affirmative defense or didn't also bring this up until the summary judgment is, in my humble opinion, ridiculous. We followed up that motion to dismiss. When it was denied, the court did not explicitly rule whether or not the ARC was a legal entity or a non-juror entity. And that issue that the court had not explicitly ruled was discussed among counsel. This issue was never a surprise. When they amended their complaint, which they did in August of 2017, their first amended complaint followed right on the heels by their second amended complaint in October of 2017. We again argued that the board did not establish the ARC, that the ARC itself, that the board was not a governing board of a planned community, and that the ARC itself is a non-legal entity and not subject to the open meeting rules of 33-1804. That's item 58 in the index. Then on summary judgment, we further argued that the ARC lacked legal existence. This was our separate statement of facts 4 through 6, item 88 in the index. And the response at item 113, they disputed that because that was part of the issue. They specifically disputed the ARC had not proven that it never existed. Of course, it's not our job to prove a negative. It's their job to prove that this is an entity which can be sued. We were in fact sued. The ARC was in fact sued. We were required to step up to court. The fact that the trial court never determined the nature of its legal entity does not mean my client were not present before the court and incurring attorney's fees. Plaintiff has argued that the court somehow erred in not providing leave to amend a third time. The rule is a denial of motion for leave to amend is a proper exercise of the court's discretion when the amendment comes late, which it clearly did in this case, after summary judgment has been granted, and after we all realized that plaintiff was about to be held responsible for not establishing a critical element of her contractual claim. And when the proffered amended pleading raises new issues requiring preparation of factual discovery. In this case, after the fact, they wanted to, in effect, do it all over again. They wanted to name the individual members of the ARC, which they absolutely could have done as early as January of 2017, and their spouses, which would have not only required a redo completely of discovery, but likely would have had the effect of precluding me because of conflicts which would have arisen between me represent entities and now having to potentially represent individual parties. The fact that those issues remained at summary judgment is actually irrelevant because the court had reached a decision on the three predicates. 1, the structure is a barn. 2, the CC&Rs permit donkeys. And 3, plaintiff failed to establish a fundamental element of her contractual claim. Mind you, this is not, as set forth in their brief, a minor discovery violation. Extensive discovery was done. A ton of depositions. 2,000 pages. Plaintiffs themselves produced 9 separate disclosures and supplemental disclosures and amended their complaint twice. The discovery and disclosures deadline had long since passed before they were held responsible for their error and are now trying to back it up and blame everybody but prior counsel. Plaintiff has not shown an abuse of discretion, no unreasoning action, no action of the trial court that was done without consideration or in disregard of the specific facts and circumstances presented to it. The determination of summary judgment was not a sanction under Rule 37. That argument, by the way, should not be before this court because it wasn't raised below, but a ruling on summary judgment that the plaintiff did not meet their burden of proof, has not set the elements, is not a discovery sanction. There's no authority that links those two. There were other reasons for the denial of the leave to amend. The court found that there was no good cause for amending to add new info, you have to read that in quotes, after the deadline, because the info they were relying on was information that we were all aware of as of October of 2016 when the original complaint was filed. The court ruled there was no legal excuse as why new facts, rate damages, were not previously timely disclosed. They just said they want to do over, but they never really explained why they didn't do it in the first place. The court ruled that the defendants would be substantially prejudiced because we're forced to litigate again with brand new defendants, and that no legal excuse had been offered for why those defendants were not named earlier. They asserted it was my fault. The court said that's not a legal excuse. And of course, it would necessitate a new round of discovery. And finally, the court found that doing so would provide a lack of certainty which is supposed to flow from the court's final rulings. All of those valid reasons require an overturning by this court if it finds an abuse of discretion, which has not been proven by plaintiffs, hardly even been argued, let alone proven. I think I've touched on the attorney's fees issue. The one case that was cited by plaintiff, Lisa v. Strom, is not on point. That case is about fees which were asked for by a litigant who was an attorney and who represented himself. That simply is not the case for any party in this litigation. And unless the court has any specific questions, I've got 30 seconds left.
Thank you, counsel.
Thank you.
Mr. O'Leary.
I want to touch on a few things mentioned by counsel on the arguments that we've already had briefly. I won't be able to get into the remainder of our appeal, but I do want to touch on and mention the Wall case in regards to barn versus RV garage, and the Wall case in determining what it was, a barn or not. It mentions it was done by the jury. It's a question of fact. There were plenty in the underlying record. Whether or not it obviously is disputed, it's still a question of fact. There was a barn expert listed. There was, photographs that Your Honor saw. There was an application to the county permit.
Specifically to their point is they said there was no evidence that this had ever been used for a garage. Do you have any controversy?
No, the use isn't, but the use, I argue, is only one factor in determining what this building actually is. The record has several things that should have been submitted to the trier of fact and not as a matter of law ruled on by the trial court.
Very well, counsel. Thank you very much.
Thank you, court.
Counsel, we appreciate your arguments today, presentations. We appreciate your briefing. We will take the matter under advisement. We'll issue a written ruling in due course. We stand adjourned.